Hello, my name is Cliff Marchek. I'm the Coordinator of Community Service at the William S. Boyd School of Law, where we provide legal education classes to the public free of charge. We have created a series of videotapes or DVDs on certain aspects of the law, and this particular section will be focusing on divorce with minor children of the marriage. Now, I have previously provided a tape on divorce without children, and with respect to the procedures of a divorce, I'm going to ask you to review that video because I'm not going to go over the procedures as heavily here as I did in that particular video. In this video, I'm going to pay special attention to the issues and procedures as they relate to minor children. You'll know from the previous video that if you can come to an agreement on all issues, and in this case we would include custody, visitation, and child support with minor children, you can get divorced without going to court, but you must decide who's going to have primary physical custody, who's going to have visitation and when, who's going to pay child support to whom, and for how long. In divorces with children, the three primary concerns with children are custody, visitation, and child support. Now, there are two types of custody. There's legal custody and physical custody. Legal custody has to do with who's going to make material life decisions affecting children or have access to material information relating to children. That is, who's going to decide what type of medical care they get and have access to the medical providers and doctors, who's going to make decisions about education and be able to have access to the teachers and report cards, and third, what type of religion the child's going to be raised under. Those items come under the heading of legal custody, and generally the parents should have what's called joint legal custody, meaning both parents should have a say and have access to this important information relating to children. The second type of custody relates to physical custody, and that has to do more with possession. Who's going to have the children and when? Now, there are two primary configurations of custody. One is called joint physical custody, and the other is called when one parent has primary physical custody and the other parent has visitation. Joint physical custody should be no less than a 60-40 timeshare with the child, probably during the week. It could be 50-50. It could also be 60-40 under recent case law to be considered joint legal custody. The other type of custody is where one child resides primarily with one parent and the other parent has visitation on an arranged basis. An example of that would be if one parent had the child or children from, say, Sunday at 6 p.m. till Friday at 5, and the other parent had them from Friday at 5 until Sunday at 6. The parent that had them from Sunday to Friday would be the primary physical custodial parent, and the parent that had them from Friday to Sunday would be the non-custodial parent and would have visitation. All decisions relating to custody are made and based upon what is in the best interest of the children. It's not what's more convenient for either parent. It's most certainly not based on the avoidance or minimization of child support. It's based on what is in the best interest of children. All custody cases are fact-specific, meaning every case is different, and all cases are based on what are called totality of facts and circumstances of the parents. There are certain factors under Nevada Revised Statute 125.480 that the court will look at. Some of those factors include which parent is more likely to promote visitation with the other parent. They're going to look at the relationship the parents have with the children. They're going to look at who's been doing the primary caregiving for the child, taking to school, taking to medical, taking to extracurriculars, feeding, clothing. These are important factors. Who's been supporting financially the child. Certain things that could have a dramatic impact on custody are as if there's been any domestic violence in the case. If one person is found to have committed domestic violence against the other parent or a child, that has to be considered in a custody case, and obviously it's going to cut against the aggressor. The court can look at any type of substance abuse that could affect parenting, mental infirmities or physical disabilities that affect parenting. So custody is a totality of the facts and circumstances. Now, before you go to trial, there's a lot of procedures set up in family court to assist you to resolve custody before a trial. After the complaint and answer have been filed, the parties are required to go to mandatory mediation. And that mediation center is in the family court building at 601 North Pecos. Either party can go in and request it. The mediation center will contact the other party and set up a mutually convenient date for the parties to come in together to work with a mediator, or what I call a facilitator, to come up with a parenting plan. Now, the parties are required to attend in good faith. The parties are not required to come up to an agreement if one of them or both of them believe it's not in the child's best interest to come to an agreement. And the mediator is not a judge. He or she is generally not an attorney. They're usually probably a caseworker or a social worker. They're there to assist the parties to come to an agreement. And if you do come to an agreement, the mediator will prepare what's called a parenting plan, which will give the basic weekly timeshare, as well as specify if it's joint legal custody. But they can also build in all kinds of specifics in that parenting plan for all the special days during the year, including all the holidays in which there's 3-day weekends, the bigger holidays such as Thanksgiving, winter break, spring break, children's birthdays, Mother's Day, Father's Day. They can build in many, many specifics tailor-made to the parties to resolve this issue. If the parties do come up with a parenting plan and sign it, it will be submitted to the judge, and the judge will make that parenting plan an order of the court, and you've resolved custody without actually having to go to court. If you cannot resolve it in mediation, then you are going to go to trial or to what's called an evidentiary hearing in front of the judge, and the judge will decide this most personal decision. It's important, if you are on track for trial and you're unable to settle this matter, to get competent legal counsel to assist you to bring evidence to court with you. It's important to bring admissible evidence to court to assist you or to assist the judge in making a decision on custody. If you have reached an agreement, that is a parenting plan, after mediation or before mediation, that's possible, and there are no other disputed issues in your case, meaning you've decided on who gets what community property, assuming there is any, and debts, you've had decided on whether or not anyone's going to receive alimony or not, and if so, how much and how long. Once you've resolved all those issues, then you don't need to go to trial. You simply need to prepare the materials to get divorced, as was described in the previous class. In particular, you'll need to get the decree of divorce, an affidavit of resident witness, a courtesy copy of the complaint. Both parties will have to sign the decree, a request for summary disposition, and you can get divorced that way, or you can set the matter for a prove-up hearing, and the case is resolved. Once there's been a custody order, custody can be modified. And generally, custody modifications are done through what are called motions. Motions are very useful. Motions can be filed to change custody or to establish temporary custody during the pendency of the case. So let's take an example. Let's say a complaint and answer has been filed and the parties have set up mediation. And we're talking now as if there has not been a final agreement. either party can file a motion for temporary physical custody, temporary child support during the pendency of the case to build in some structure until the case is resolved. Once there is a decree, a party can file a motion to change custody. And you need to show at least that it's in the best interest of the child that custody be changed. The one exception to that is if the parent who has the non-custodial parent, that is the parent that has visitation, wants to have primary physical custody, you must show two things. One, it's in the child's best interest to change custody, and two, there's been a material change in circumstances since the last custody order. It's important for you to consult an attorney before you file such a motion. Another issue relating to minor children is relocating out of state. Once there has been a custody order, if a parent wants to leave the state permanently with his or her children, a couple things must occur. First, the parent that wants to leave the state with the children must have primary physical custody. If he or she doesn't, you must file a motion to change custody first. If the parent does have primary physical custody, then the parent has to do one of two things to leave the state. One, he has to get written permission from the other parent to leave the state, and you're going to have to come up with an alternative visitation schedule most likely, and deal with travel expenses. The second way is for that parent to file a motion to relocate out of state in front of the court. The legal criteria to leave the state with your child permanently is that the relocation must be based in good faith, meaning that the parent that's relocating isn't simply leaving the state to frustrate the other parent's visitation. And two, there must be an actual advantage to that parent and the child or children. Now, this issue has been heavily litigated in our state for the last 20 years because it pits two fundamental constitutional rights against each other. That is the freedom to travel versus the right of a parent to have a meaningful relationship with his or her child. Things that the court will look at are where the motive for leaving in good faith. Will there be a reasonable opportunity for the non-custodial parent to have a meaningful relationship with his or her child once the parent is relocated? The motives of the non-relocating parent, and many other factors. If you are in this circumstance, it is important that you consult an attorney before embarking on this type of motion. As an aside, what I am not discussing and will never be able to discuss in this class is whether or not it's permissible to leave the state with your child if you don't have primary physical custody or any type of court order. The reason that cannot be addressed is it could range all the way from being perfectly okay if the other parent doesn't care and maybe impliedly consented, to ranging up to felony kidnapping. So if you're in a situation where you have not gotten a final order on custody and you want to leave the state, you must consult a competent attorney to determine whether or not that's a good idea or not. I want to talk to you now about child support. In the state of Nevada, both parents are required to financially support their children, and child support is generally set on a percentage of the non-custodial parent's gross monthly income, and I'll get into what those percentages are in a minute. However, if the parents have joint physical custody, child support is set a different way, and I want to introduce that concept to you now. If both parents have what's called joint legal custody, joint physical custody, which means that they have at least a 60-40 timeshare, then you set child support by calculating the appropriate percentage, subtracting the lesser from the greater, and the person making more will pay the difference to the lesser earning spouse. For example, let's say the parents have decided to have joint physical custody. And there's one child, you would take 18% of the father's gross monthly income and set that. So we'll take, for example, let's say 18% of the father's gross monthly income is $700 a month. And you take 18% of the mother's gross monthly income, and let's just say, for example, she makes 18% is $500 per month. In that case, the father would pay the mother $200 a month in child support, even if there was joint physical custody. The only way that you would not have a child support order in a case with joint physical custody is if both parents made the same. Now, generally, the way child support is set is a percentage of income, and it's for one child, it's 18% of the non-custodial parent's gross monthly income, 25% of the non-custodial parent's gross monthly income for two children, 29% of the non-custodial parent's gross income for three children, and then it goes up 2% thereafter per child. Child support will be set at a minimum of $100 per month per child, regardless of income. And if the parent makes in between brackets of income, then it gets set on a rebuttable maximum amount. For example, if the non-custodial parent makes between $2,830 per month, but not greater than $4,235 per month, currently under Nevada law, that amount is $630 per month that parent would pay. If the parent makes $4,235 per month, but not greater than $6,351 per month, that parent will pay no greater than $693 per child per month in child support. If the parent makes between $6,351 but not higher than $8,467, that parent will pay a child support per child of no more than $758 per month. If the parent makes between $8,467 per month but no more than $10,585 per month, that child will pay a maximum amount per child of $819 per month. And it goes up additional brackets between $10,585 and $12,701. The current amount is $883 per month. And then if someone was to make between $12,701 per month but less than $14,816 per month, that child support would be set at $945 per month. Now, that's the current law. Every year in Nevada, the legislature will adjust that rebuttable maximum to reflect the cost of living. There are other factors that can cause child support to deviate. Deviate's a term that means it could result in the child support going up or down. Health care and medical is a joint obligation of both parents. So if one parent's providing health insurance for a child and there's an out-of-pocket expense to that parent, that can result in child support going up or down depending upon who's paying for it. For example, let's take a case where the mother has primary physical custody, let's say, and the father makes an income where his child support would be $700 per month. Well, let's also assume that the father provides health insurance. And remember, the father in my example is the non-custodial parent and the mother is the custodial parent with primary physical custody. But let's say the dad provides health insurance and it costs him $200 per month to provide health insurance just for his minor child. He would get a reduction of $100 off his child support to reflect that expense. Other factors that can cause child support can go up or down are the cost of child care, any special education needs of the child, the responsibility of parents for the support of others, the value of services contributed by either parent, any public assistance paid to the child, any expenses related to the mother's pregnancy and confinement, the cost of transportation of the child to and from visitation if the custodial parent moved with the child from the jurisdiction which the court has ordered support and the non-custodial parents remain current, the amount of time the child spends with each parent, and the relative income of the parties. If there are any other additional factors, the court may consider those. Now, child support lasts until the minor child turns 18, graduates from high school, or 19, whichever is later. A parent can go back 4 years for child support if no order has been set, but that's the maximum amount that the court can order what's called child support arrears. Child support can be reviewed, and under Nevada law, it can be reviewed every 3 years, but it's the responsibility of one of the parents to bring that child support review before the court. The court does not automatically calendar these 3-year reviews based on your decree of divorce or your order for paternity, custody, and support. So it's the obligation of one of the parents to bring that child support review just to see if child support should be raised or lowered. Child support can also be changed if there is what's called a change in circumstances, and this has been interpreted to mean if there's been a 20% increase or decrease in the non-custodial parent's income, then the parent can bring a motion to modify child support even before the 3 years expires. For example, let's take a case where there's been a divorce decree and one parent receives primary physical custody, or it could be joint custody and one parent still paying child support. But let's say the parent paying child support loses his job in 6 months, or her job, and now is receiving unemployment, making substantially less than he or she was before. That parent could come back into court before waiting for 3 years and ask that his or her child support be lowered based on the changed circumstances of losing his or her job. Child support is enforced in a number of ways. One way is to do a wage assignment or wage garnishment. If one parent becomes 30 days late with a child support obligation, the other parent can issue a wage assignment to his or her employer, and the money will be taken directly from the employer and paid to the spouse entitled to child support. If one parent's having difficulty receiving any money, and let's take, for example, the other parent's not working, the parent who's not receiving money can file a motion for an order to show a cause to see why the non-complying parent, that is the parent not paying child support, should not be held in contempt of court. All judges have the power of contempt to enforce their court orders, and this is applicable in a child support situation also. Third, you can go to the district attorney's office and ask them to implement a wage assignment if you don't want to do your own wage assignment. Child support is an obligation of both parents. Both parents are required to financially support their children. It's very unusual that a court will order or issue a decree of divorce or order of custody without one parent paying some form of child support. And when you file your action, you should request the appropriate amount based on Nevada law. Thank you very much.